Good afternoon, everyone. Welcome to Medicaid Monday. It's the second Tuesday presentation that we've been doing this year for 2019, covering topics relevant to Medicaid, and today a little bit of Medicare, care management, and other things pertinent to our clients and their advisors. We are sharing our webcam, so please note that your lines are muted. If you do have questions, you can email them to us at info@pirolaw.com. And at the end of the webinar, you can link to a free consult. Calling or viewing with a case in mind, we'd be happy to sit down and talk to you about that case. And you'll find that link right at the conclusion of the webinar. So there will be a short survey for you to complete as well. And if you have any technical problems, it does happen, then you can also email info@pirolaw.com. So questions or technical issues, info@pirolaw.com. I'm Lou Pirro, part of Pirro, Connor, and Strauss. With me is my partner, Aaron Connor.
Good afternoon, everybody.
We have with us Nora Barato, who is one of our geriatric care managers, AKA life care coordinators. And the first thing that we're going to start with this morning is Medicare and Medicare appeals. Many people falsely believe that Medicare is going to cover a lot of long-term care services. It will not, but there are certain benefits under Medicare that do become valuable. And one of the primary benefits is Medicare skilled coverage. If you are admitted to a hospital, and admitted is a term of art, that means you are not being observed, you're not on observation status, you've been formally admitted to the hospital, and you're there for 3 days, you have a 3-day stay, that triggers potential skilled care coverage in a rehabilitation facility. And Medicare will pay 20 days in full and 80 days with a copayment. And the copayment is up now to about $174 per day. So as you go from hospital to rehab to nursing home custodial placement to home health care, there are a lot of transitional services. And I'm going to turn it over to Nora to walk through some of the issues that you may face that are appealable and what your rights are to file that appeal. Nora?
Good afternoon. So when you have a stay in a skilled nursing facility, as Lou had mentioned, you really need to make sure that you know what the status is in the hospital. Many people get tripped up on observation versus inpatient stay, and you really need to have an admission order from the physician to have an inpatient stay and be eligible under straight Medicare for a 3-day qualifying hospital stay for skilled nursing coverage in a nursing home. There is an exception to that under managed Medicare plans. They often will waive the 3-day qualifying hospital stay, but they will tell you up front that they qualify for a short-term rehab stay. So when you transfer over into a nursing facility, what's really important is that individual who is going for a short-term rehab, that they really need to make sure they understand that they have to actively participate in the rehab program. If they refuse physical therapy and there's a pattern of more than 2-3 times, even though they're not feeling well, they could be denied because they're not showing progress. So that's really important that people understand that. What the facilities are looking at and the insurance companies are looking at is that you're showing continued sustained improvement. And if you're not doing that for a variety of reasons, and sometimes people are sick, and that's the valid reason, but sometimes insurance companies will deny, and you have that right to appeal and say, during that period, that individual was sick and had since been diagnosed with pneumonia or whatever the health condition is, and now that that's been addressed, they can resume their therapies. In the event that denial is issued, you have the right to appeal that denial, and you get a letter stating what the reason for the denial is. And you really need to make sure that if you're signing, that you got your appeal letter, that you know what your rights are, and you read that letter and make sure you understand it. If you have any questions, I would reach out to the skilled nursing facility staff member or the plan itself. For Medicare, you have Levanta, and it gives you a step-by-step instruction as to what steps you need to take. You need to usually call the Levanta number, and in cases with your managed care plan, you can call the number and tell them that you want to appeal, and they will do an internal review. And then once that review is done, then you have another extended appeal rights.
So, Aaron, one of the things in a Medicare appeal is that insurance benefits often piggyback off of the Medicare win.
Mm-hmm.
So Medicare supplement policies sometimes will have copayment days and copayment coverage, but you don't get your insurance coverage unless Medicare is picking up the tab.
Correct. And what we see clients trip up over most, I think, is the time periods. These things never get better by waiting. Many of them have very strict time periods. Mm-hmm. And if you're going to appeal, even if you're doubting whether you might appeal, you're better off filing the appeal paperwork and withdrawing it. Because once the appeal right is gone, you can't get it back.
Right. And there is a series of lawsuits that have been filed by Medicare beneficiaries. The Medicare Beneficiary Defense Fund is the plaintiff in many of those. And those are based upon the government and providers applying the wrong standards for the determination of whether skilled care coverage should continue. And so 20 days in full at what's now about a $500 a day private pay nursing home rate is $10,000. And if you have Medicare supplement coverage that has the skilled care benefit, and generally letters C and F in some of the Medicare Advantage plans will cover that additional, and now C and F are going off the boards for next year for Medicare supplement. So I believe it's D and G that will be available to provide skilled nursing care coverage. So when you're looking at that skilled care coverage and you get another 80 days, again at $500 a day, there's $40,000. So this appeal could be theoretically worth $50,000 if skilled care coverage is wrongfully denied. And that now is on the Medicare Beneficiary Defense website, several cases that they have been victorious in. And the one case that is the most famous or maybe infamous is the JIMMO, J-I-M-M-O v. Sebelius decision. And that was litigated by a number of plaintiffs in a class action because the federal government was teaching the incorrect standard. They were using an improvement standard that you had to be improving on a day-to-day basis, not just participating, Nora, but improving. And that wasn't the law. But that's how they were teaching the facilities to interpret the law. And so JIMMO got a permanent injunction against that, and the government had to go back and retool all of its decision-making and instruction. But there was JIMMO 2 because they weren't complying with JIMMO 1, so they had to go back and resue to get it started again. So those rights are critical, they're important, and do not assume that the facility or the people interpreting the standards are always using the right standard. And Nora, just a little bit about how you go about reviewing the record and what your role is in the appeal process.
Well, my role is really be an advocate for that individual and really guide them through the process. We get requests of the medical record, and we'll look at the medical records and guide the family in the time frames and making sure that we meet the guidelines. In the medical record, again, we refer to as the differences in interpretation, and really it's presenting and gathering the facts and presenting it back at them in language that they can understand of what a skilled need is.
An appeal can also be used really to delay things from the standpoint of whether we need to place somebody today or 3 days from now. which may not sound like a big difference, but can make a critical difference in availability.
And finding a bed.
Yes.
Yeah. So I would say, and maybe more than delay it, buy time so that you get a few additional days, which can be the difference maker. And also, if you're planning on transitioning back home and you're getting the skilled rehabilitation therapy, it's a fluid situation, Nora, because people in skilled care are rehabbing. So many of them are improving on a day-to-day basis, not just maintaining. But you don't know sometimes where the highest rung on that ladder is that they're going to get back to.
Right.
And when you're preparing a home care plan and a transition home and you're arranging for home health services, having an ability to keep that Medicare paying until they get to a level that can be transitioned home is important.
And I think one of the things that I see a lot of times in the skilled facilities, they're saying, oh, well, they're ready to go home. And, when talking to the staff, you say, well, are you letting them do their own ADLs? They tend to keep doing the ADLs and keep assessing them. And what's really important is that they give them that trial run of, while they're in a supervised environment, that they're making sure they can do all their own care. They can get in and out of their chairs and taking all those things into consideration, which sometimes there is that gap in communication.
And families are not prepared for this. They're not equipped. They don't know what the rights are. They don't know what should be happening in terms of that type of transition planning and the testing for ADL performance. And you go right into the nursing home with the families as a care manager, correct?
Right. We follow them. If we get the call while they're in the hospital, we really follow them across the continuum. And I can't tell you how key that is, because there's so many different levels of professionals that they're dealing with that it's extremely confusing, and they need that advocate that's looking out for them and not, what the system is dictating, that they move them along as fast as possible.
And Aaron, sometimes the attorney's role, and we've done this on several occasions, we've done appeals, we've written letters, we've gotten involved on an advocacy basis at that point. And just quite honestly, sometimes a lawyer's letter goes a little further than a care manager's pleas to get that care extended.
It does. Sometimes it's difficult because you don't know who you're going to get it to or what the response is going to be. But generally, you get more because people are just fearful that a lawyer is involved.
Yeah, we can rattle our sabers a little bit and get the attention of the administrators at the facility, sometimes more so than just going through the record and filing a written appeal. So Medicare, we wanted to start with, and it's an important right, one that does now add up to big dollars if you can keep the rehabilitation going. And it is a vital part of any transition planning to get from hospital to rehab to home. And Nora and I did a presentation on just that, how to transition back to the home, but keeping the rehab going, keeping the Medicare going, filing the appeal, knowing your rights. And there are multiple levels of appeal. Very often the first level of appeal is simply an administrative appeal that goes just the paperwork to be re-reviewed. But beyond that, if there are true legal issues, you're entitled to a hearing and you're entitled to a formal appeal with Medicare. And so we have done a number of those as well. So I want to turn now from Medicare to Medicaid. And Medicaid is the program that does cover long-term care, custodial care, and home health care in New York. A bit of limited ALP coverage for assisted living. They call it the assisted living program. There are, I think, 2 or 3 facilities within 50 miles of the Capital District that are ALP beds and have some Medicaid coverage. And generally, Nora, I think those are pretty full.
Yes.
To get the Medicaid coverage for a bed in an assisted living facility, very, very limited. But home health care is available. It's gotten very tricky under the managed long-term care system. And nursing home coverage is available. And in order to get either, you have to meet these strict financial criteria. And from an asset perspective, you have to get down to $15,450. An income perspective, if you're in a nursing home, you get an income allowance of $50 per month. Everything else is called net available monthly income, or NAMI. If you're at home, you get $879 as an individual, and anything over that is supposed to be spent down or contributed to a pooled trust. So a lot of the appeals, Aaron, that happen from a Medicaid perspective are on financial eligibility.
Absolutely. Sometimes it's that gifts have been made for reasons other than Medicaid eligibility, although tends to be the toughest one. That can be one, maybe if there's a pattern of gifting over time prior to a long-term health decision.
Right. Innocent gifts, we call them.
Yes.
And if you've made innocent gifts, one of the key factors is going to be what was the health of the gift giver at the time the gifts were made. So if you're 65 years old and you've made a series of gifts under a gifting plan and you gift every year to your family and suddenly you have a massive stroke and need Medicaid, it's going to be a fairly successful appeal for saying that those transfers were made for purposes exclusively other than to qualify for Medicaid. So Medicaid wouldn't have been in the picture. And that is an appeal that is won probably less than half the time, but
Yes.
if you have good facts, it's always turning
possible.
on the facts. It is certainly possible to convince the fair hearing officer that it's transfers for purposes other than to qualify for Medicaid.
Other grounds are things that are mischaracterized as gifts sometimes. Maybe documentation that's come up later that can show that certain transactions are not gifts. Because anyone out there needs to remember that you are applying for a benefit you don't automatically get. So if you can't prove something is not a gift, excuse me, it's going to be treated as a gift. And there are other things that can come up too. Maybe we're lacking documents for identifying documents or things like that. But generally speaking, the appeals either for denials are much more to do with financial items than anything else.
So the one appeal that I'm working on currently is down in Nassau County, and it's an appeal based upon an interpretation of a rule that says an IRA is an exempt asset. Many people don't even know that to start with.
Correct.
But the question then becomes, how do you make it an exempt asset? And generally, it's by taking periodic payments from the IRA, and one of the payments is at 70.5, your required minimum distribution. So Nassau County doesn't use the standard IRS tables that Albany County uses and HRA in New York City uses. They want to use a different table, which is a social services table that has a much higher amount being paid out. So in our case, our client is a 95-year-old woman who has her only asset being an IRA, and they want to say that she has to take $10,000 a month out of the IRA in order to exempt it. That's a social service table. If we use the IRS table, as she had been doing for the previous 25 years, it's a $5,000 payout.
Yeah, we also had that problem in a county up north. I can't remember which one it was, but we were successful in getting the table applied that we wanted.
So you have to know this not only on a New York State basis, but on a county by county basis. Nassau and Suffolk use the social services table. Most of the rest of New York uses the IRS table with a few limited upstate exceptions. And so we're going to go challenge that. How can you have a standard one way in one county and a different way in the rest of the state? They need to be consistent, for one.
Yes.
And I believe, based upon my research, that it should be the IRS standard. So sometimes it's just exempting an asset. Sometimes it's you have a caregiver child and you can transfer a home to a caregiver child.
Right.
Sometimes that gets denied based upon the facts, and you may have to go to fair hearing.
Or you may have paid a child to be a caregiver,
Right?
pursuant to a
agreement.
caregiver agreement.
Mhm.
And the key to all of these things is documenting.
Correct.
So the more writings there are, and I know people think it's strange to have a contract with their children, but if you do that, you have a much, much higher level of success.
So one of the questions that frequently comes up is, do you need a lawyer to file for Medicaid? And when you read the fair hearings and the denials based upon incorrect interpretations of the law, you realize that you're not always going to get fair treatment in the process.
Correct.
So literally every Medicaid application that our firm does is prepared with a long view of litigation. If they deny, we need to have the documentation in the file from an asset perspective, an income perspective. If we're using a pool trust for community-based Medicaid,
Correct.
we have to make sure that all of that paperwork is prepared. And Nora, one of the other things that you work on is the flip side of the financial, which is the Medicaid care hours. And one of the biggest reasons to appeal a Medicaid decision right now is that you didn't get the hours that you feel you're entitled to.
Right.
So how do you go about that preparation in terms of the application?
In terms of applying for that, what we look at is, doing that assessment, and looking at what the needs are, and then when we're advocating on behalf of that person for, identifying this is what they need assistance with their ADLs in, and we do have people that, suddenly they're decreasing the care, and we get on the phone and they're advocating with that plan and telling them, this is what the routine is. Still, sometimes they deny, and we assist in that appeal. And there's again, the limited time frames. We advocate to make sure that we're getting that medical information. We're getting input from the physician, as well as the caretakers.
There's a document that should be part of a Medicaid home care application. It's called an M11Q, and it's been part of New York state law for a very long time. And what the M11Q is a task-based assessment by the physician of the need for home care for the individual. You don't want to be doing that M11Q post-decision. You want to have that as part of your application, and this is part of preparing yourself for that fair hearing. The big push now is for the managed long-term care companies, because they're on a capitated budget, to give out 4 hours or 8 hours when the need may be prescribed as 16 or 24.
Right.
And that is very often one of the appealable decisions that we fight, and for the most part, pretty successfully, as do many people who are prepared. If you have the M11Q, if you have the task-based assessment, New York put the MLTCs in this position. They capitated their payment, but didn't change the standards upon which care is granted. And so we got a decision about 2 years ago in an Alzheimer's case. It was dementia care, so it was mostly companion care. And the decision was that the woman only needed 4 hours a day because she could do some ADLs, but she couldn't do them unsupervised. Well, that wasn't the standard, and still isn't the standard. So we went to fair hearing, and the county brought the county attorney, the fair hearing officer, looked at everything, and all of the people, the staff from the county was there, and I put the regulations on the table. I said, do you know what these are? And they said, no. I said, these are the regulations that govern how Medicaid is interpreted for home health care. Have you ever seen them? Well, no. Look, those were just passed. Those were passed 12 years ago. I've only been working here 4. So no one had ever read the regulations. And it came out as a 24/7 case through the administrative appeal. And you need to know the law, but you need to know your facts. And when you're applying for Medicaid, you have to make sure that you have all the right facts in the file, so that when it does come time for a fair hearing and you're in front of the administrative law judge, you're prepared. So, Aaron, some other issues. Now, we have to exhaust internal appeals.
Right, which means when you get your hours determination, you have a short period of time to appeal that internally. All right. Unfortunately, for the most part, this is just an administrative hoop to jump through. Rarely does the company say, oh, you know what, we were having a bad day that day. You're entitled to 8 more hours a day. Okay. But during this period, 1, you're kind of getting a preview of what a fair hearing would be like. Mm-hmm. And 2, you're preparing evidence, because if you're going to win a fair hearing, it's not because you're a nice guy or because, your lawyer's super tough. It's because you're going to win on evidence. And that's all part of this process. So a geriatric care manager is an important part of that process, especially in an hours determination, because they can come in and advocate about ADLs and about how much assistance a person needs. Generally, in these situations, we're getting their primary care physician, or if they have a neurologist, if it's a dementia Alzheimer's case, mm-hmm. to say what their care needs are, because that's something the county can't really combat, because they don't hire a doctor to do their own determination. So all of those things are very good evidence. And a fair hearing really is like a mini trial, and it's just consistently like a mini litigation, meaning that the time periods to do things are accelerated. So generally speaking, fair hearing has to be filed within 60 days. All right, comes on generally fairly quick.
Pretty quickly.
And you better be ready.
Mhm.
But you need to be ready because the people in these situations need the help now,
Right.
not 3 months from now.
Right.
So that's a critical factor as well. As an aside, sometimes it takes a long time to get these fair hearing decisions, which is really unhelpful for someone waiting for care. We have seen more recently the decisions turning around quicker, which is a big issue as well.
And one other thing that is very, very vital is if you are receiving Medicaid benefits and the adverse decision that you receive from a plan is to cut your hours, you have a right. You have to file within 10 days, but you then have a right to something called aid continuing. And so if they reduce your hours, and we've seen the reductions from 24 hours to 4 hours a day, you go and you ask for an appeal and for aid continuing, and you will have that aid on the basis it was already previously granted until your appeal is finally determined.
That's right.
So aid continuing is a vital request, and you have to make sure you make it along with your fair hearing request so that you keep the aid that you have. And now with so many different types of Medicaid applications, you have the standard application with a managed long-term care company, but you also now have something called immediate needs, which goes directly to the county. They're supposed to turn that application down for home care within 12 days. And we're fighting with a county right now that has delayed and beyond their time frame. One of the things that we do is file a fair hearing request for failure to render a determination. And we do the same thing. They have 45 days to turn a standard Medicaid application around. If you don't have a decision from the county, you file for fair hearing. And that puts the state on notice that the county isn't complying with the time frames. So filing for a fair hearing is sometimes done with no anticipation that we'll ever have to go to a fair hearing.
Correct.
Because usually you get a response pretty quickly once you've filed. But again, aid continuing, if you are already on Medicaid, is a vital right to have. So the deadlines?
Generally 60 days from an adverse determination for a fair hearing. If you miss that period, you're done. So again, in litigation and situations like these, waiting does not do you any good. That the hearing, again, is a hearing with an administrative law judge, not a judge wearing a robe, but someone with just as much authority, at least in the Medicaid arena. And you're going to have testimony, more than likely. You're going to have an adversarial party on the other side, probably a Medicaid worker and a county attorney.
Mm-hmm.
And you're going to have to make your case to the administrative law judge.
And there are precedents for fair hearings.
Correct.
There is a data bank of fair hearing decisions that's maintained by the Greater Upstate Legal Project, and we use that extensively to see how issues have been decided in prior fair hearings and how administrative law judges have written those determinations and those decisions.
Absolutely.
So you have rights in the internal appeals process, but the ultimate right is for an administrative fair hearing. And so once you exhaust that, or it's deemed exhausted, the fair hearing is where you very often get the decision that you're looking for, because there is precedent here. They have to abide by legal standards here. And this is where the law will really start to come into play, not just an administrative determination by an agency that, again, it's unfair to them, but it's unfair to the consumer too. They have X dollars to spend and you need Y amount of care. There is a dynamic tension there. And in order to get your rights fulfilled, sometimes it's necessary to go to that next level beyond the administrative appeal.
That's correct. And as I said, most times the administrative appeal is not successful. You have the fair hearing. And if the fair hearing is not successful, you have further appellate rights after that. We rarely these days see those exercised in Article 78.
So I've litigated up to the New York State Court of Appeals, which the Supreme Court in New York is not the last court, it's the first court you go to. So you do an Article 78 from a negative fair hearing decision, and you basically sue the state. And we've done that a number of times, most times successfully, sometimes not, depending upon the issue. Sometimes we just try to get things for clients that are not on all fours with the facts or the law because we have a colorable claim. But generally, we've been successful through the appellate process. And I've done appellate division cases and Court of Appeals cases for Medicaid eligibility determinations. The typical appeal today is ours. It's MLTC, and that usually doesn't get beyond a fair hearing. So knowing your rights is critical, and Aaron, you do much more of the litigation than I do. What should people be aware of in finding a lawyer that does this?
Well, one, you need a lawyer who does this. Okay, you don't need a matrimonial lawyer. You don't need a criminal lawyer. You need someone who's experienced in these areas, someone who's done administrative appeals, someone who knows what a litigated situation is like and how to handle it, how to prepare for it, what documents they're going to need, and what questions are going to be asked. So experience and knowledge in the practice area are the biggest keys.
And again, I've been doing this for 37 years, and we have great colleagues across New York State. The elder law section of the New York State Bar Association is a tremendous resource, and we vet all of these issues with other attorneys, Renee Reichsich in Rochester, Valerie Bogart in New York City, and they are on the pulse of this on a day-to-day basis, and they file federal class action lawsuits all across the country. And so we have colleagues behind us that are really good at making sure that everything is being done by the state that should be done. Okay, I think our half hour is up. It's a quick overview of the appellate process for Medicare and, more importantly, Medicaid denials, the fair hearing process and litigation beyond, your MLTC appellate process, which is administrative at this point. But knowing your rights and preparing your Medicaid application for success is the key, because as you said, Aaron, the paper trail is everything when you go to fair hearing.
Absolutely. And if you don't know what you're doing, expect to be denied. And if you haven't prepared, expect to get a low out number.
All right. So one more slide, and that is where you can go ahead and ask for a consultation. So you can click there right on the screen, or you can email us at info@pierolaw.com. December Medicaid Monday, I mentioned that there are assisted living facilities that do accept Medicaid payment, and that is the ALP program. It is a very limited, specific program. I was on the board of an ALP called Macaulay Residence, which was run by the Sisters of Mercy for about 10 years. And I can tell you that the amount of reimbursement that those facilities get makes it very, very difficult to balance your budget and to run. And in fact, Macaulay Residence no longer operates, but there are a few here locally, and we're going to talk about those on the second Monday in December. And we hope you can join us. And again, remember, there are fair hearing webinars, Medicaid webinars that are on our website. Medicaid Monday is posted. You can go to pierolaw.com and get all of the past webinars on Medicaid eligibility, home care, nursing home care, and a whole host of other topics. Thank you for joining us today. We're very happy that you could be with us, and we look forward to seeing you on future webinars.